Court does call the case of the people versus Anthony Taylor.
Good afternoon, Your Honor. People. Hey, Your Honor. Good afternoon. James Vitelski appearing on behalf of Mr. Taylor, who is approaching.
Yes.
Please state your name. Good. Anthony Taylor.
This is your motion. Go ahead.
Your Honor, we are asking the court to modify what is currently a $300,000 cash or surety bond. As I've outlined pretty extensively in my motion, Mr. Taylor has no prior convictions, and of course, then we have no prior violent history or history of absconding or not showing court hearings. He served honorably in the Marine Corps in his younger adult years and was honorably discharged. He also graduated from Eastern Michigan University back in 2006, I believe it was, with a bachelor's in business and computer science, and has worked in the IT security field for 20-some years or so. This is a gentleman who has never had any issues with the law outside of the accusations made in this case, which, with reference to what the people have articulated in their response, I would just note that even assuming there's some truth to these allegations, we dispute and we'll put our defense forward as we can through this process. There's no allegations of any sort of violence or behavior that would, especially when these children now are under the family court jurisdiction and also being supervised by DHHS, I assume, because of the CPS termination case that's pending. My client will not be anywhere near these kids without there being some kind of arrangements for supervised visits, which I think is highly unlikely until this case is fully litigated. Lastly, I spoke to my client's mother. Her name is Mary, and I believe she's 78 years old. Lives in Belleville on the home where he was raised, along with 9 other siblings. She sounds like a wonderful, very religious woman who told me that she has relied on his assistance at the house. He could live there with her. He could be placed on house arrest there. And I'm not exactly sure where the children's mother lives, but I think it's somewhere in Ann Arbor. So Belleville from Ann Arbor is a significant distance, and again, the kids would be under their mom's her custody, and I think a significantly lower cash 10% bond with strict conditions like house arrest and GPS tether would be certainly sufficient in the broader context within which Mr. Taylor appears to this court. So I'm asking the court to consider a reduction to $100,000, 10%, with either house arrest, GPS tether, any other conditions the court needs. And if the court even wanted to have his mother appear in court, she's a lovely lady, and I'm sure she'd be able to verify that she would keep him accountable at her residence where he would also be able to help her.
Response.
This time, Your Honor, the people would object to any modification of bond and actually ask this court to deny the defendant's bond. As I know, this court is abundantly aware, Michigan Court Rule 6.106B1B allows this court to deny pretrial release to defendant charged with criminal sexual conduct in the first degree if the court finds that proof of the defendant's guilt is evident or the presumption of rape, unless the court finds by clear and convincing evidence the defendant is not likely to present a danger to any other person. I'd like to direct the court's attention to page 7 of my response to the defendant's motion, specifically the allegations substantiating the charge of criminal sexual conduct in the first degree was provided by the minor victim, the defendant's daughter, during a forensic interview at the WCAC, in which she stated that on one occasion, she asked the defendant what he was doing, to which he responded, just covering up. The minor victim then disclosed the defendant was touching her vagina with his head or his hands, and that she believed that her father was either licking or blowing her vagina. It was unsure if anything was inserted into her vagina, which substantiates the charge of criminal sexual conduct in the first degree. Additionally, Your Honor, I don't believe that there's anything within the defense motion to substantiate a claim that defendant is neither endangers the community or is not a flight risk at this time. That's it.
Briefly, Your Honor, I think with regard to the CSC1 accusation, the last statement that counsel read off, according to the forensic interview, she was unsure if anything was inserted. There may be stronger evidence for a CSC2, but in terms of bond not being permitted on CSC1, that's like a murder 2 or murder 1 charge. I just don't think it is abundantly clear that the evidence substantiates that.
Yeah, but your argument, Nick, fails to take into account what will constitute penetration on a CSC.
Well, I understand that at least under the law, any penetration, no matter how slight, can be sufficient for a CSC1 conviction, but this is a case where I believe that was the sum and substance of her statement in terms of the CSC1 charge. And I don't believe there's any other evidence that would otherwise either corroborate or help prove that in any fashion like forensic evidence. So we may well be having a trial ultimately on CSC2 charges, but we
Why? I don't understand that argument. I don't understand that argument.
Well, whether or not there's probable cause for a bind over on a CSC1 charge will be determined at some future date.
Yeah, but again, your argument has a problem. Your argument has a problem in the sense that if the question's asked or what is said was anything inserted, that in and of itself can be a certain statement. That doesn't mean that there wasn't a CSC1 if there is other penetration.
I believe I'm following Your Honor, and I don't believe there's.
I don't think you are.
Evidence that there was penetration.
Pardon?
I don't believe there is any evidence that there was penetration. There may be evidence of allegations of contact, but I don't believe, from what I've seen so far, there's evidence of penetration.
I think the case law, as I read it, based upon what this individual is saying, would constitute penetration.
I do have the monitoring instructions. So you're like to read loud.
No, I don't need them. I know what they say. I mean, and so then the question becomes on that CSC1, if that is testified to, what's been stated, that could constitute a CSC1. And it would seem to me that if this witness gets up there and says that, it is a great likelihood that this defendant would be convicted. I'm not saying he will be, but I'm just saying that's not what I have to decide as to whether or not he will be at this time.
And all I can say at this stage is we have not had testimony. There has not been the process of cross-examination to get clarity on what she meant by what she said. So that will be our next stage in this process. I would just ask the court.
So why wouldn't I, under the court rule, given what has been presented to the court, actually change this bond and deny it at this point?
Because I don't think the evidence is abundant, or it's so clear that there could be a reasonable question to be decided at preliminary exam as to whether or not the CSC1.
So why wouldn't I deny his bond at this point, let the exam happen, and then whoever has it revisit the bond? But based on what's in front of me at this point, why wouldn't I just deny his bond?
Well, I think certainly the court would be within its right to do so, and I understand that certainly is a way these cases are handled in many situations. I just think that there's a lot of compelling reasons why a bond reduction would be appropriate given the safeguards the court can put in place. Even bearing in mind the context of the allegations of the situation. Not a random stranger. He's never had a history of just going out there violently attacking them. I understand what the allegations are.
Yeah, but I don't need all of, I understand what you're saying, but I don't need all of that under the court rule, right?
I think that it's still, these are still factors for the court to weigh out to determine whether or not the no bond or some other bond is appropriate. Because I personally don't think that the no bond portion of the court rule applies given the facts as we know them. This is not such an abundantly strong case that there may not be a reasonable dispute or a reasonable issue, at least at preliminary exam and subsequently a trial, even if it is found out. So from my vantage point, I still think there are reasons to look at all the factors.
Anything else from the people? Well, Mr. Rafetsky, if I do that, is there anything, if I deny his bond, is there anything or consider denying his bond? I mean, the one thing is that the court would then have to find that he's not a flight risk. But that almost shifts it. I mean, so tell me why he would not be a flight risk.
Well, I don't think he has really anywhere to go or any other motivating people or places that he would go to, especially given the fact that he's always loved his kids. After divorce, they had a 50% custody arrangement. So working through these processes in the legal system and being close to family like his mother and siblings who are in Southeast Michigan, he wouldn't have anywhere to go besides probably Southeast Michigan. And if the court wanted a passport, if he has one, surrender that. And again, I think a house arrest would be significant, especially at these early stages for the court to be confident in his appearance and in safety.
Right, I probably should deny the defendant's bond. I'm not going to do that at this point in time. I'll let it certainly proceed to preliminary examination if the people wish to raise that at an additional time, and certainly the court would consider that. But I certainly am not at this point going to reduce the defendant's bond. The defendant's bond motion for bond reduction is denied. Bond will continue as it's set. Thank you.
Thank you, Your Honor. And on the PCC part of this, we're asking for an adjournment. There's still some discovery we're waiting on, so can we have a date in 2 weeks?
Probable cause conference, April 3rd, 2025, 9 a.m.
Thank you.
Thank you.
Thank you, Your Honor.